We're on the record, Your Honor.
Okay, good morning. In the matter of Norcutt v. Council, case D16-537499D. I see that. Well, let's see. We had Mr. Council shortly ago, I think. You can turn on your cameras.
Good morning, Your Honor. Yeah, I'm trying to get connectivity. Having a few issues, so if you bear with me just one moment, I apologize.
Okay. Ms. Norcutt and Mr. Page, you can turn on your cameras. And Sheila.
Yes.
And Ray?
Yes. That would be Mercer from Jeffrey Abrams' office.
Oh,
Camera's being low.
He's a law firm. He's on the next case.
oh, okay,
On the sealed case at 9.
okay. Mr. Counsel?
Yes, Your Honor, I apologize. Having connectivity issues.
All right. So,
Got it.
welcome everybody. Mr. Page, may I have your bar number?
080
080, no, we missed something there.
6080.
Okay, very good. All right, so we're here purportedly for the decision. However, there's a couple of issues we need to address. I need everybody to turn their mic off, please. And first, let's address the drug test results from Mr. Counsel. Well, before we get to that, let me address something else. Mr. Page filed and served 3 documents in the recent history. One was on June 28th, one was on June 29th, and one was on July 13th, just yesterday. I mean, the information that's provided is certainly relevant, but I don't know whether or not it's appropriate to include it after a trial. Let me hear your arguments in favor of the court considering it, Mr. Page, and then I will hear Mr. Counsel's response.
The information was received via subpoena. It was received after the close of trial as it relates to Mr. Counsel's income that he had, but he didn't report it. The information should come in because it allows the matter to be heard on its merits. We've heard Mr. Counsel testify throughout the course of the proceedings that he didn't have a job, didn't have money. The information provided unambiguously impeaches Mr. Counsel as to those claims that he made. So under those grounds, I think it's relevant. It gives the court information as to determine what he was actually earning. So I think it's important in that regard. As to the information regarding the drug test results, we got the drug test results also after the close of the proceedings. So that was something in order to give the court context as to what, for lack of a better term, what the test results mean. And I think that's important. I mean, obviously he did test positive for a number of things, including ecstasy, so it would be worthwhile to include that and have that be a part of the record for some context. And the other part was the schedule of child support arrears. That's obviously important because we have to determine how we got those numbers. We testified in closing argument as to what those numbers were for the schedule of child support arrears. This gives the court something in writing to go off of. So it's really kind of a documentation of what we stated on the record during our closing argument.
Okay, however, Mr. Counsel hasn't had an opportunity to rebut this, or, so,
I suppose-
so let me just tell you, my inclination is to, if you want me to include it, which I agree, I think that these 3 documents are relevant, but I think that he needs to have an opportunity to respond to it, perhaps in more than just a verbal response here today. So I would, and then, I don't, as far as the child support arrears, I almost feel like we might need some testimony to support that, or I don't know, because I don't have any of the documentation to support these entries. It looks like this was prepared probably by somebody from your office.
Actually, this was prepared by me. It was, curiously enough, it was prepared during one of the breaks we had during trial, because my client had presented an audit from the Office of the District Attorney as to what payments were made when. I simply transferred those numbers provided by the Office of the District Attorney into the MLaw program. Then the program automatically calculated the interest and penalty. That's why I provided the basis for the numbers that we argued at closing, because I'd done the work during one of the breaks.
Okay. And then I'm looking for cumulative arrearage, cumulative interest. It doesn't have, and as we both know, penalties were discontinued as of 2020, but there's certainly, child support issues that preceded that in which penalties would be permitted, but I don't see the column for penalties in your document.
I don't recall if I clicked off the box that included penalties because it was a child support payment. I just don't have a specific recollection.
Okay.
Let me pull up in front of me so we're both working off the same document.
Okay, thank you.
Quite frankly, it looks like I could modify the schedule of arrears to discontinue any of the penalties after 2020. So while it's close, it's not as precise as is potentially possible. I'll agree to that.
Okay, thank you. Mr. Counsel. Mr. Counsel, can you hear us? Mr. Counsel?
Oh, hello. Hello, are you there? I'm
Yes.
sorry, can you hear me?
Now I can hear you.
I apologize. I'm having technical difficulties with the reception, so I apologize.
Okay. Mr. Page has filed these 3 documents, and just wanting to know if you would like some time to respond to them, or do you want to address them now?
No, Your Honor, I need time to address these because I'm sorry, I just having a little difficulty trying to find where he got these information, and most of it, I don't know. It doesn't seem to be official or anything. I'm not sure, but yeah, I would like a little bit of time. I don't know how much time that you would grant. Kind of like I object to submitting the documents after the fact. He's had plenty of time to do it, and it just seems this is a Hail Mary. But you know, I believe it's. I just need a little bit more time.
Well, as far as the child support arrearages, what Mr. Page is saying is that the document he provided is based off of the information that was on the Nevada Child Support Enforcement sheet that you provided during trial as Defense Exhibit L. However, I will note that there are some entries on Mr. Page's child support arrears schedule that are not contained in the printout that was produced during trial as Defense Exhibit L. So I don't know the origin of those, don't know the accuracy of those.
I'll double check my work. If there's extra
Yeah.
entries, I'll verify each entry again in addition to adjusting the penalties.
Okay.
I object, Your Honor. He's had plenty of time to do this, and it's like at the last moment, these documents. I'm not sure. Are you talking about the payments that were made? Exhibit L.
What was your question?
Is it Exhibit L the payment schedule that was the payments that were made?
As I understand Mr. Page's statement, he used that Defendant's Exhibit L, the one you produced,
Correct.
to prepare this schedule of arrears. However, there are some additional entries in this document that are not correct. I think that this document could benefit the court if it were accurate. I just don't. I note that there certainly, as Mr. Page just acknowledged, there's some penalty calculations that should be eliminated from February 1st, 2020 to the present time. And he already acknowledged that that's something that he will revise. But I'm not sure of the origin of the rest of these entries that are not contained in the document that you provided. And Mr. Page just said that he'll take another look at that. But it would be certainly a useful tool for the court if the accuracy were verified. So I would like to have that revised and to give you an opportunity to verify the accuracy of it,
Okay.
Mr. Counsel. All right. So
Okay.
that addresses the child support arrears document. Another document that Mr. Page produced was a supplemental exhibit regarding defendants' unreported income from Curaleaf. And I understand, as from a practitioner's perspective, how frustrating it is when you subpoena documents and they don't arrive before trial. However, this one arrived after trial, and it does appear that the subpoena was sent in the month of June 2021, which is the same month that this trial occurred. So it was not likely that the information would have been available during the trial. However, if I would like for you to respond to this document, Mr. Counsel, okay? You don't have to respond here and right now. This document was served on June 29th, and if it is accurate, then it would certainly be relevant for the court's consideration. So have you seen that document, Mr. Counsel?
No, I had an issue downloading it from the site because I've had bad signal and bad connectivity. So I'm not clear exactly to what it is because I've tried to download it multiple times and I can't get it to download. And I tried to upload a couple things yesterday and I don't know if they uploaded either. So I apologize.
Okay,
I will
give you one opportunity to review it. Tell me your email address.
It is alexcounsel@sbcglobal.net. ALEXCOUNCIL@sbcglobal.net.
I didn't get that.
At SBC Samboy Charlie Global.net.
Okay. Is that
Thank you.
Is that an email through an employer?
No, it's my personal email I've had for years.
Okay. All right. Mr. Page, would you please email that to him again? And what is your mailing address, sir, so that Mr. Page can also mail it to you?
Of course, it's P.O. Box 33492, Las Vegas, Nevada 89133.
I do note that when I'm looking here at Odyssey, Mr. Counsel did open the email on June 29, 2021 at 4:50 p.m.
That is correct. I've tried to open it and download it. However, as I stated a minute ago, I had connectivity issues and it did not download.
Okay.
Today is July 14. It seems unlikely that there would be connectivity issues continuous between June 29 and July 14.
I would agree, and I would also agree that well, I've never heard, I don't know, maybe Mr. Page has a different experience. I've never heard of anybody not being able to download the documents that are served through the district court's e-service system. Have you, Mr. Page?
No.
It went to download, and then I'm not sure what happened with my PC. It may be my PC completely. I'm not sure, but I've tried multiple times, and I don't know. I can't download other things as well.
Okay.
Not only just from you guys, from other sites. So it might be actually my computer has issues.
Well, also you knew that the document was there, so you certainly could have contacted Mr. Page's office and asked him to mail it to you.
Your Honor, I've tried to contact Mr. Page's office, and it just goes round and round and blatant put downs and harassment from Mr. Page.
Mr.
So
Page,
I apologize.
Page, would you please mail a copy of this document to Mr. Counsel?
Thank you.
Yes, I will. And Mr. Counsel's representations of emails that were harassing or put downs to him is absolutely false. We asked him to honor the court's orders or obey the court's orders as it relates to financial obligations that he has in this case.
Okay.
Your Honor, I can submit the emails for your review. It was, I don't want to get into he said, she said, or any kind of more disrespect.
We're not going to, Mr. Counsel. All right.
Thank you, Your Honor. I appreciate that.
You're going to mail that to Mr. Counsel. You're also, Mr. Page, please mail in the U.S. mail to that P.O. box this document, the
you.
results of the subpoena from the Curaleaf subpoena. Mail that to him. Mail the e-file and e-serve your updated child support arrears. And then as far as the plaintiff's supplemental exhibit regarding interpretation of defendant's drug screen results, that was filed yesterday. Mr. Counsel, have you had an opportunity to review that?
I didn't actually see the results. I tried to call in to the court as it was noted. I was not able to get through. However, I tried to upload my doctor's note yesterday, and if you remember my statement about that drug test, I did say humiliate, because it was humiliating. The fact that I tested positive for a substance that was not of my consent. I was roofied and I was robbed and mugged in Mexico City. I provided the flight that I was on, and then I also provided my doctor's note that I was not able to fly home that date because I was too ill of being roofied and mugged and robbed in Mexico City. It was not of my consent. I've never tested for that drug before. I've never used that drug before. I don't even know how it happened. However, I was at a dinner and it happened, and then I was mugged and robbed of my belongings, and it was an extremely humiliating instance. Okay. And then as far as the other items, the other items in my system, those are prescribed by a physician and a doctor and are completely legal. I submitted my prescriptions to the testing facility. I'm not sure if they provided those to the court. However, I have prescriptions for everything, and I am underneath a doctor's care. Mr. Page is not a doctor, nor is he a physician. So that, and his emails that I was stating to were harassing. He was calling me an addict. He was putting me down, calling me blatant names that are completely false and untrue. It's the fact that I am under doctor's care for prescriptions that I do take, and the fact that I was roofied and I was mugged out of my consent.
Mr. Counsel, when were you in Mexico City? When was that event?
The 30th of June.
June 30th?
I was there from, May 30th. I was there May 29th, 28th, 29th, and the 30th. The 29th, I was there working, I had an interview with a possible United States manufacturer. And then the 28th and the 30th was a travel day. And I uploaded that to the system last night for the court to review. I'm not sure if you saw that or got those because I've had connectivity issues, but I uploaded the flight itinerary to show that I was in Mexico City flying back. And then I also provided my doctor's note stating I was ill, and the fact that, I couldn't even fly. I couldn't even get out of bed. I couldn't walk. I couldn't even get anywhere. And I don't speak Spanish. So I was literally humiliated all on my own with basically just trying to get a flight, get home, and recover the best of my ability.
Mr. Counsel, where did you upload documents last night? What?
The Odyssey, electronically, filing accepted. I really need you to help me remember that. I really need to. Last night at 6:47.
Uploaded it to where?
The e-file.
There's nothing there.
I can screenshot this and send it to you. I did upload it last night. I got the email back from it. The email filing accepted, courtesy copy of service, was sent at 6:29 back to me. I'm sorry. That was Mr. Page. Looks like I did it at 6:49.
Okay, so the court will note you indicate you were able to upload something. It's not in the court's records. And also you indicate that you've had email communications with Mr. Page. But you also note that you've had connectivity issues and haven't been able to download documents that have been emailed to you. So,
Well, yeah, from the e-file Nevada. Yeah.
so that's all inconsistent and does not make sense.
Well, Your Honor, I uploaded it last night. Business trip to Mexico with doctor's note.
Okay, so for the record, the court finds that Mr. Counsel submitted to a drug test on June 17, 2021, and he tested positive for hydromorphone, hydrocodone, both of which the drug test result indicates his prescriptions have been verified by the laboratory. He also tested positive for moderate usage of THC metabolite positive, which is legal in Nevada. The court further finds that Mr. Counsel tested positive for MDMA ecstasy, 530 picograms per milligram, which is in the amphetamine family, and also MDMA ecstasy positive for 755 picograms per milligram, and these positive test results indicate previous regular user who has stopped using for the past 2 to 5 months. Also, the amphetamines can be unstable in the hair. A low or moderate level may also be due to the breakdown of the drug from higher levels. At the time that the court referred Mr. Counsel to American Toxicology Inc., Mr. Counsel stated that it was humiliating, and he provided, when the court questioned him about that comment, he provided some explanation that made no sense to me. So I don't even remember what it was that he said, but it made no sense to me. And then now today, because the test result comes back positive for ecstasy, he states that he was humiliated because he was roofied in Mexico City, which I don't have any recollection of him mentioning at the time that the court referred him to the drug test. Do you recall him mentioning anything about that, Mr. Page?
He did not.
Okay. All right. So what I'm going to
Your Honor,
I'm going to continue this hearing to allow Mr. Counsel the ability to respond to Mr. Page's supplemental exhibit regarding the subpoena from Curaleaf, and I'm going to allow Mr. Page the ability to update and revise the schedule of child support arrears, and then I'll discuss the decision. So we will come back. But before we find out that date, Mr. Page, I'd like for you to comment on what you would like the court to do after these drug test results.
Right now, all contact between Mr. Counsel and Gage should be suspended. Gage should not be required to travel from Seattle to Las Vegas.
objection, Your Honor.
Mr. Counsel,
Seriously.
Mr. Counsel, we don't interrupt here, remember? Go ahead, Mr.
I'm
Page.
sorry.
Because Mr. Counsel has tested positive for prohibited illegal substance, there is a grave danger that Gage may be in imminent danger of substantial bodily harm. We don't leave children unsupervised with people who use illegal drugs. Mr. Counsel is a user of illegal drugs. Therefore, until such time as he completes some sort of drug counseling or drug rehabilitation through the patch program or some similar program, all in-person visitation should be suspended until such time as Mr. Counsel can show that he can test negative for all illegal substances. I would recommend that he participate in the 6 months patch program to ensure full compliance.
Okay, thank you. Now you may respond, Mr. Counsel.
Your Honor, this is preposterous. This entire case, for the lack of 2 years, and since the court allowed the other party to relocate to Seattle, has been filled with alienation, lies, and deceit to the court by the other party. I have no issues with my child. My child and I have had a strong bond since birth, stronger than his bond with his mother, and I've had multiple witnesses testify of that, while the other party had one witness testify, and she didn't even know his color. And the fact that the other party didn't even know my son knew how to ride a bike. She clearly said he doesn't know how to ride a bike when I submitted to Mrs. Moss pictures of him riding a bike, and I taught him how to ride a bike.
That's
It's
Judge,
just, Your Honor,
that's Judge
this whole-
Moss. That's Judge Moss, Mr. Counsel, and you're talking. You're getting off track. I know that you had multiple
listen, I have
witnesses. Excuse me. I know you had multiple
sorry.
witnesses testify about your character and football in the initial days of the trial that was held before Judge Moss. I've read those transcripts now. But this doesn't have anything to do with the drug test results. So,
Okay. I have not tested positive for drugs in the past, illegal drugs. Let me emphasize that, since Mr. Page likes to say illegal. Everything that I've always tested for has been under prescription by my doctor and my physician. Mr. Page is not a physician, nor is he a doctor. THC is not illegal in the state of Nevada.
we're only
And
addressing the ecstasy, sir.
And I submitted my doctor's note stating that, and I was roofied. It was not of my consent. I've never used that before. I've never tested positive for that before. I've had no urge to even touch that before, Your Honor. This was a one-time isolated event that was assaulting to me, and my character, and my belongings. And it was not of my consent. I had no control over it.
I have no evidence of that, Mr. Counsel.
I understand your point, Your Honor, but in the past, I've never tested positive for it. I was in Mexico City. I have the flight itinerary. I've uploaded. I can email it to you. I've also provided my doctor's note stating I was too ill to even travel. I couldn't even walk. I couldn't get care because I didn't speak Spanish. I was completely all alone, and it was an isolated one-time event.
Do you have a police report?
No, Your Honor, the Federale in Mexico are the cartel. I was advised not even to reach out to the Federale.
So where is Gage currently?
He's with his mother in Washington. By the way, he's had 2 prior positive drug tests during the history of this case, so it's not isolated.
No, I have not. They were positive, but they were also under a doctor's care with prescriptions. So I object to your falsified statements. Everything's under prescription, Your Honor, every single thing, except for that isolated event. And there's never been any history of drug use in the past of illegal substances ever. And if I had, I wouldn't even be able to coach football. I mean, it's just preposterous what his claims are. And I have not been able to reach my son for weeks because the other party prevents it. I've called, I've texted, I've tried to email, I've got it all on my phone. I've screenshotted it, I've screen recorded it. This case is about alienation, manipulation, and money. The other party is all about money. No one has ever said anything about the interest of my best interest of my child. It's all been focused around financials and fraudulent claims.
When is the next time you're scheduled to see Gage?
I'm traveling. Like I stated last time, I have to travel the beginning of this month. I have to travel home to take care of my mother, and then I would like to have him either fly there or fly to me back in Las Vegas when my mother comes back with me to Las Vegas. She's looking at relocating to Las Vegas because her health would benefit from being out on the West versus the Midwest. So like again, I was still looking for unemployment to look around. You know,
So there's been
as soon as I get back from my mom,
there's been no contact since we were here for
no,
trial?
she's prevented it. I can't reach him. I've tried to call. I've got text messages. I've screenshotted. I recorded me calling him to where there's no answer at all. Dead air. I cannot contact my child. And it's wrong.
That's not true.
Okay,
It is very true, Your Honor.
No, he has a phone with him that I pay for, a track phone that he can reach him anytime. And
Your
I have
Honor,
this
I screen recorded it. I've got screen records of it. I can submit that to the court. I can provide everything to the court like I have in my complete exhibit packet. She is completely
true.
making fraudulent statements. She has
It's not
alienated
true.
my child. She has poisoned my child. She has poisoned both of my children with falsified facts that saying I'm a druggie, drug user, and all these things that I'm not. It's legal prescriptions. And I wish that you would stop making fraudulent statements about my character that is damaging to my children and how they look at their father. It's wrong.
The court may wish to review the guardian ad litem report wherein Gage indicated he didn't want to visit with his father over the summer as well. The guardian ad litem report was quite
Fueled
detailed.
by alienation by the other party, by manipulating, telling him that I'm a druggie and all these other falsified things that you're not supposed to tell my child.
Okay, we're getting way off track here.
I understand and I apologize. But it's just wrong, Your Honor. I can't contact my child. I can't reach him.
That's
He's
not true.
almost 15.
Stop. Okay,
Stop.
I'm going to mute
I've
everybody.
got-
I'm muting
Thank you.
everybody's mics right now. So stand by. Okay, we will come back tomorrow. No, not tomorrow. Excuse me. Friday. Do y'all have time Friday at 3 o'clock? You can turn on their mics again.
Okay. Fine.
Okay, I'm going to turn on the mics again. Mr. Page, you do... Well, no, that's not going to give you enough time to get me the updated schedule of arrears. Or it's not going to give him enough time to be able to respond to this.
All due respect, Your Honor, I would request 30 days at least.
All right. Okay.
Thank you.
Okay. So when can you get me the updated child support arrears schedule, Mr. Page?
I'll do it today.
Today? All right. So we'll come back in 30 days.
Thank you.
August 9th at 8:30?
I need at least an hour.
An hour? Okay.
Looks like I've got August 11th at 8:30. August 11th at 8:30. We can go. We can block off. That will work. August 11th at 8:30. Are y'all available?
Yes.
The 11th is good, Your Honor. Yes, thank you very much.
Okay, so August 11th at 8:30. I want Mr. Page, please update the child support arrears by no later than, let's see, I'll give you till the 21st. July 21st for the child support arrears. And Mr. Counsel, if you would please respond to these documents by 11th. The 30th. July 30th.
Your Honor, could you give me at least till the 6th with travel and mail and everything? Unless you can.
Well, I guess I can.
Thank you, Your Honor. I appreciate that.
So I'll give you August 6th for the response
Thank you.
to these three documents. And then, Mr. Page, if you want to reply to his response,
Your Honor,
then, yeah, well, that's not going to give you much time to do it, so. I don't know, you can make oral arguments regarding his response, that's fine. Okay,
We'll do.
so we'll be back on
You're-
August 11th. Yes, Mr. Counsel?
Your Honor, I apologize. I submitted a fob a while back that was had electronical stuff on it, such as like audio recordings, screenshots, such and so forth. That's evidence in my case. I have all of the recordings of me trying to contact my child that will prove to the court, but with beyond any reasonable doubt. Can I drop off the fob to show that?
No.
Or can I just
no.
show it in court?
No, I don't
Okay.
have that before
Okay.
me, sir. This
No, I was wondering if I could do.
No, this case is
Okay.
only about the narrowed issues that were before the court, and they were financial. They were child.
No, I understand, but I understand that, Your Honor. But the other party is trying to prevent me from seeing my son after they have successfully succeeded on preventing me from contacting him,
Mr.
which is
Counsel,
completely alienation.
Mr. Counsel, that's not before the court. So we'll see everybody back on August 11th at 8:30. Thank you.
Thank you, Your Honor.
Court's adjourned.
A couple of